All right, this is chapter 16, the writing requirement in our digital world. So, first, this chapter pretty much goes over all the requirements about what you need to write down and other things in a contract that in order for it to actually be valid and for it to stand. So, if it needs to be in the proper form. So, states all have different, it varies per state, but some contracts require writing. So, starting off, each state has a statute of frauds, which like originates back in England, and so they explain which contracts need to be in writing, and it was created to ensure that there is reliable evidence of a contract. So it always should be in writing or written memorandum, or also could be put on electronic record. It has to be at least one of those three options, and so there's mainly five different things that it talks about that need to be under these three different types of writing. Um, First is land interest, also a long-term contract like the 1 year rule. Collateral, if you're going to pay off someone else's debt. Marriage, and also if something is said to be worth $500 more, whether it's a sale or something, then it has to be under written contract. And so first off is land interest, and you have to describe your property very distinctly in the contract, just like the case in point in the book explained that for this guy was selling a gas station and only put the address, and so the other party turns out they didn't want it, so they went back on the contract, and the court's like, sorry, you only did the address, so it wasn't really laid out clearly. So they also have number two, the 1 year rule, because pretty much they explain that us as humans have terrible memory, and if it's over a year, we probably won't remember an oral contract, so you need to put it in writing. Number three is collateral, which is where you have a third party that may be assuming your debt or whatever the contract lays out. And obviously, if someone else is going to pay off your debt, you probably want to have that in writing. Fourth is marriage. This has to do with like prenuptial agreements, also other stuff like where you have to do before marriage, like who's going to get what if the marriage doesn't work out, and also just $500 or more. Both of the parties' intentions. That's number five. $500. Pretty simple. If it's over $500, just make sure you lay out what's going on. And there's also exceptions to some of these things. So partial performance, like if it's already been, the contract is halfway done and you want to like back out, then the court can rule different ways. Also, if someone admits under oath that the contract was done, if they did an oral contract and someone admits it, then it is considered to be under writing, or someone probably wrote down that you admitted it. Also, one of these things some states have is, in my notes I wrote down promissory estoppel. I don't really know how to pronounce it, but pretty much a person is justified if a person justifiably by the court relied on a person's promise, so they really needed it, then that's that. The book also explains some special exceptions in sales contracts, like there's some it went into a little bit of detail, but they said they would explain it in a different chapter. Signature must also be on every document, and they explain that it could be your initials, or it could be printed at the bottom, or it could be a real signature, probably your best option. So they also had a definition of writing, which is an order, confirmation, invoice, sales slip, check, fax, or email. And these things can be more than just one document or one piece of paper, because sometimes it takes, the book explained, might have to send one thing and then they have to send something back to confirm it, and it ends up being more than one document. Pretty much it has to contain all the essentials, all the essential terms. It doesn't have to be everything. If you want to just say one small thing to the other party, then that's fine, but it needs to have the essential things and also what parties are involved in the contract. So lastly, explain the parole evidence rule, which is so pretty much it explained that the contract is final, and whatever oral things that were said, if it's not in the contract and no one admits it, then you go always back to the contract. That's what's final. If it's ambiguous or if it's been modified. And so an integrated contract, the book explains lastly, is the final statement. So if a thing is final, then it's an integrated contract. And that's about it. Let the chapter explain.